I'm going to talk about the procedure that happens after an individual has been interviewed by the Royal Military Police and the Royal Military Police have decided to refer the matter to the commanding officer or the Director of Service Prosecutions with a view to prosecutions being brought against that individual. So in the examples I'm going to give, I'm going to assume that there has been an investigation by the Royal Military Police. The individual will have been interviewed under caution by the Royal Military Police. They may have answered questions, they may have made no comment, they may have given a prepared statement, and there may have been one or more interviews under caution. But at the conclusion of the investigation, the Royal Military Police have decided to refer the matter for prosecution, have re-cautioned the individual, and the matter now moves forward away from the Royal Military Police into the responsibility either of the commanding officer or the Director of Service Prosecutions. The commanding officer has limited powers of jurisdiction in relation to offences. Commanding officer can only deal with some offences. So, for example, commanding officer can deal with offences of absence without leave, can deal with offences of misconduct towards a superior officer, can deal with offences such as fighting. But there will also be offences that a commanding officer cannot deal with, or can only deal with if they have previously received higher authority. So an example of an offence where a commanding officer would not have jurisdiction to deal would be coercive and controlling behaviour, or more serious forms of assault, or more serious sexual offences. Those are matters that a commanding officer would have no jurisdiction to deal with, and it would have to go to the Service Prosecuting Authority. The Service Prosecuting Authority are then obliged to consider the Code for Crown Prosecutors in exactly the same way as the Crown Prosecution Service is required to consider the Code for Crown Prosecutors. And the Code for Crown Prosecutors comes in two parts. You have the evidential test, and then, if the evidential test is passed, the public interest test. So, considering the evidential test first, the Service Prosecuting Authority must consider whether, looking at the evidence that has been presented to them, there is a realistic prospect of securing a successful prosecution. The Service Prosecuting Authority are not obliged to prosecute every case. So, for example, the Royal Military Police may have investigated, and just as an example, an offence involving allegations of domestic violence. And it may be in that case that the alleged victim either has not given a statement, or has made a retraction statement, or otherwise does not support prosecution. In that example, it may be that the Royal Military Police consider that they have sufficient evidence to refer for prosecution. But the Service Prosecuting Authority may conclude that in the absence of any witnesses, any complainant, any witness statements, they may conclude that the evidential test is not met. So the evidential test, is there a realistic prospect of conviction? Now, if the answer to the evidential test is yes, there is a realistic prospect of conviction, then the public interest test follows on from that. Now, in more serious offences, the public interest test is frequently met. So, for example, if there was an allegation of grievous bodily harm, it would be unlikely that if the evidential test were met, it would obviously depend on the circumstances, but it would be unlikely that the public interest test would then not be met. But there may be examples in a military context, for example, someone with an unblemished career coming to the end of their time with the services, that it may be, in some circumstances, that the public interest test is not met. So in conclusion, just because an individual has been referred for prosecution by the Royal Military Police, it is not automatic that they will go either to the commanding officer or to the Director Service Prosecuting Authority, and a decision will be made that they must go to court martial, it's still necessary to apply the Code for Crown Prosecutors. In the meantime, the individual could use the time that they have to prepare a defence, and that may include speaking with potential witnesses, taking site visits, gathering evidence, considering social media, what has been put on social media, if anything, about the individual concerned, gathering material that will assist them in the defence. And of course, there is no property in a witness, so if an individual considers that it may be helpful for prosecution witnesses to be spoken with, that can also be done. There is plenty of work that can be done between the decision to refer for prosecution and any subsequent prosecution itself. There is a considerable period of time in which a defence can be prepared.